much. We've just tabled in the House of Commons Bill C-31, Protecting Canada's Immigration System Act, which will strengthen the fairness and integrity of Canada's generous immigration and refugee programs. Je viens de déposer devant la Chambre des communes un nouveau projet de loi C-31 intitulé Loi visant la protection du système d'immigration du Canada, qui renforcera à la fois l'équité et l'intégrité des programmes généreux de l'immigration et de l'octroi de l'asile du Canada. This bill will further improve Canada's asylum system following the passage of the Balanced Refugee Reform Act in the last Parliament. It includes measures to crack down on human smuggling, which had previously been introduced and debated in Bill C-4, the Preventing Human Smugglers from Abusing Canada's Immigration Act. Finally, this bill will enable the introduction of biometric technology into our immigration system, which will prevent known criminals, failed and deported refugee claimants, and other deportees using fake identity from obtaining visas. In doing so, Bill C-31 will facilitate legitimate travel to Canada by bona fide visitors, students, business people, and others. Our refugee system is amongst the most generous in the world. It is internationally recognized for its fairness. And in fact, Canada welcomes 1 out of every 10 resettled UN Convention refugees worldwide. We already welcome more resettled refugees per capita than any other country, the second most in absolute terms after the United States, and we're in the process of increasing the number of Convention refugees who we resettle by 20%, so that we will clearly be the world leader in refugee protection and resettlement. We are also giving those resettled refugees more support to ensure their success in Canada through a 20% increase in the Refugee Assistance Program. Just this week, I met, for example, with some of the gay Iranian refugees who we've helped to find protection and begin new lives here in Canada, several dozen who have joined us in the recent past. But for too many years, our generous asylum system has been abused by too many people making bogus refugee claims. Canadians take great pride in the generosity and compassion of our immigration and refugee programs, but they have no tolerance for those who abuse our generosity or take advantage of our country. Our government is very concerned about the recent increase in refugee claims from democratic countries that respect human rights. Our asylum system is already overwhelmed by a large backlog of cases. The growing number of bogus claims from European Union democracies is only exacerbating the problem. Too many tax dollars are spent on people who do not need our protection. In fact, about 95% of all claims from the European Union have been determined by our system, and mainly by the decisions of those asylum claimants themselves, to be unfounded, either by those individuals withdrawing and abandoning their own claims, and over 90% do that, or by their claims being examined and rejected by our Fair and Independent Immigration and Refugee Board. En outre, il existe un trop grand nombre d'avenues permettant aux demandeurs d'asile déboutés de retarder leur envoi du Canada après que la CISR a pris une décision juste à l'égard de leur demande. À l'heure actuelle, 4 années et demie s'écoulent en moyenne entre la date de présentation de la demande initiale et le renvoi du pays d'un demandeur d'asile débouté. Dans certains cas, plus de 10 années se sont écoulées. Il en découle un système surchargé et un gaspillage de deniers publics. Nous dépensons du temps précieux et l'argent des contribuables depuis trop longtemps pour des personnes qui n'ont pas besoin de notre protection, et ce, aux dépenses des demandeurs d'asile légitimes qui n'ont d'autre choix que d'attendre leur tour dans une trop longue file d'attente. Ça veut dire que ça prend 21 mois pour un demandeur d'asile légitime, quelqu'un qui se fuit l'Iran comme victime de persécution, de torture. Il faut attendre souvent plus de 21 mois pour obtenir une audience auprès de la CISR pour obtenir la protection du Canada, en partie parce que 62% des demandeurs d'asile sont trouvés les faux demandes, les demandes qui sont rejetées ou retirées. Nous dépensons du temps précieux, comme j'ai dit, et il faut donner la protection aux vrais réfugiés de façon beaucoup plus vite. Pour tout dire, le système de l'asile du Canada est défectueux, c'est brisé. To be blunt, Canada's asylum system is broken. That's why Parliament passed the Balanced Refugee Reform Act in 2010. The Act contains a long-needed improvements that will result in faster protection for real refugees and quicker removal for bogus refugee claimants. That act went a long way towards addressing problems in our system, but it's become clear that there are still some gaps and that further reforms are needed. We need stronger measures that are closer to the original bill that we had tabled back in March of 2010. The measures I am announcing today build on the reforms passed in the Balanced Refugee Reform Act. These new measures will further accelerate the processing of refugee claims for nationals from designated countries that generally do not produce refugees. They will also reduce the options available to bogus claimants to delay their removal from Canada, which delay sometimes takes years and years. In fact, it takes us at least 4.5 years to be in a position for an average bogus refugee claimant to have run the course in all of the various appeals that they have, and then it takes us sometimes quite a lot longer to actually remove them from Canada, which is virtually an encouragement for people who want to come and abuse our generosity. We are determined to prevent this abuse of our system, and in a time of fiscal restraint, we are committed to ensuring that our asylum system is as streamlined as possible while remaining fair. At the same time, those who truly need our help will get it even faster. Canada will continue to exceed all of our international and domestic legal obligations, for example, our obligations under the Charter of Rights and the United Nations Conventions on Refugees and Torture. La hausse du nombre de demandes d'asile présentées par des personnes en provenance de pays démocratiques sûrs est un phénomène bien documenté. Il s'agit là d'une réalité de plus en plus préoccupante. Par exemple, le Canada reçoit plus de demandes d'asile de personnes provenant de démocraties de l'Union européenne que de personnes provenant de l'Afrique ou de l'Asie. En fait, 23% des demandes d'asile reçues par le Canada l'année dernière ont été présentées par des étrangers de l'Union européenne, qui viennent du pays où il existe des solides droits démocratiques de la personne, ce qui représente une hausse comparativement à 14% l'année précédente. Réfléchissez au coût pour les contribuables. Presque la totalité des demandes présentées par les ressortissants de l'UE au cours des 2 dernières années ont été rejetées, abandonnées ou retirées. À ce rythme, les coûts pour les contribuables canadiens imputables aux faux demandeurs d'asile de l'UE l'année dernière s'élèvent à près de 170 millions de dollars. C'est là une des raisons pour lesquelles je présente aujourd'hui ces nouvelles mesures visant à renforcer davantage le système de l'octroi de l'asile. Nous accélérons le traitement des demandes d'asile. Plus particulièrement, les demandes d'asile présentées par des personnes venant du pays démocratique respectant les droits de la personne, comme ceux de l'Union européenne, seront traitées en environ 45 jours, comparativement à plus de 1000 jours dans le système actuel ou à 171 jours au terme des réformes adoptées l'année dernière. We will speed up processing of refugee claims. In particular, the refugee claimants from democratic rights-respecting countries, such as those in the EU, will be processed in about 45 days compared to more than 1,000 days under the current system, or about 171 days under the reforms adopted in 2010. Claimants from designated countries of origin will also have their claims heard sooner and will not have access to the new Refugee Appeal Division that we are creating. Proposed changes to the designated country of origin policy will enable us to respond more quickly to organize waves of fake claims from safe, democratic countries by changing how countries are designated. We will limit access to taxpayer-funded social benefits and work permits for refugee claimants from designated countries of origin to reduce the pull factors that often bring people here to Canada with illegitimate claims. And I should say the provinces have an important role to play here. We encourage provincial governments to review their welfare and other benefit programs to ensure that they are not contributing to pull factors for bogus claims. Refugee claimants from these countries will be ineligible to apply for a work permit and associated benefits until their claim is approved by the IRB in which case they're considered a bona fide refugee, or it has been in the system for more than 180 days without a decision. As a result of quicker hearings under these proposed measures, failed claimants wouldn't be in Canada long enough to actually obtain a work permit, with which goes access to various federal social benefits. To be effective, faster decisions must be complemented by timely removals. We are sending a message today. If you do not need Canada's protection, we will give you access to our fair asylum system quickly and then send you home quickly. You will not be allowed to remain in Canada for years using endless appeals at the expense of Canadian taxpayers. But to those who need refuge, these proposed measures will help you to get protection even faster. And through the creation of the Refugee Appeal Division, the vast majority of failed claimants from the vast majority of countries around the world will now, for the first time in our system, have access to a full, fact-based appeal at a quasi-judicial tribunal, the Refugee Appeal Division. It's important to note that all eligible asylum claimants will continue to get a fair hearing before the IRB. Because it's important that today's measures do not change Canada's reputation as having one of the most generous and fairest refugee determination systems in the world. Un autre composant du projet de loi C-31 s'attaque au passage des clandestins. Il y a plusieurs mois, notre gouvernement présentait le projet de loi C4 qui cible l'entreprise lucrative et sans pitié qui est le passage des clandestins, tout en maintenant notre tradition de longue date d'offrir l'asile aux réfugiés, tradition dont notre pays est fier. Le projet de loi C-31 remplace en effet la loi visant à empêcher les passeurs d'utiliser abusivement le système d'immigration canadien, tout en conservant presque toutes les mesures comprises dans le projet de loi C4. Ces mesures contribueront à préserver l'intégrité de notre système d'immigration généreux, tout en mettant un frein à l'utilisation abusive de ce dernier par les passeurs dont les gestes minent la sécurité des Canadiens. Je crois que je ne dois pas pencher sur les détails parce que vous êtes déjà au courant, mais je peux toutefois dire que nous avons apporté un amendement important au projet de loi C4 dans le projet de loi que nous avons présenté aujourd'hui. Ça veut dire que les mineurs de moins de 16 ans ne seront pas visés par les propositions liées à la détention conçues pour prendre des mesures à l'égard de tous les autres étrangers désignés. Ça veut dire que, effectivement, on va clarifier que les mineurs de moins de 16 ans qui sont dans une situation désignée, une situation de passage désignée, seront exclus de l'exigence de détention de l'immigration pendant 12 mois. Permettez-moi de souligner une autre disposition très importante du projet de loi. Une fois que la demande d'asile d'une personne aura été approuvée de la CISR, cette dernière sera remise en liberté. Donc l'idée qu'on va garder toutes sortes de réfugiés légitimes qui sont arrivés dans les situations clandestines en détention pendant 1 an, c'est faux, c'est tout à fait faux. Effectivement, la grande majorité des demandeurs, des réfugiés de bonne foi qui sont arrivés dans les situations clandestines seront libérés dans un délai de 2 à 3 mois, je dirais. Compte tenu de la rapidité du système d'octroi de l'asile que nous proposons, cela signifie que, comme j'ai dit, les clandestins seront remis en liberté dans le délai de 90 jours. It makes sense to include these anti-smuggling provisions in the same bill as our balanced refugee reforms, as the two sets of proposals are in many ways quite complementary. Both of these sections of Bill C-31 deal with amendments to the Immigration Refugee Protection Act. Both deal with threats to our immigration and refugee system. In the one case, highly organized waves of unfounded claims from safe democratic countries, and on the other hand, highly organized human smuggling operations. Finally, I'll just say that the bill includes an important legislative authority for long-planned implementation of biometrics as an identity management tool in our immigration and border control systems. This is a key part of the Canada-U.S. Security Perimeter Framework Agreement between President Obama and the Prime Minister in December. This legislation and regulations that will follow will allow our government to make it mandatory for certain visa applicants to have their photographs and fingerprints taken as part of their temporary resident visa applications. Documents can be forged or stolen, but biometric data provides greater certainty, confirming the identity of applicants when they apply. and this is necessary. La mise en œuvre de la biométrie mettra le Canada en conformité avec un nombre croissant d'autres pays qui utilisent déjà des technologies similaires, comme le Royaume-Uni, l'Australie, les États-Unis et davantage des pays européens. Le projet de loi C-31 permettra la mise en œuvre de la vérification des données biométriques qui devrait s'amorcer l'année prochaine. And I should just highlight that we have seen many cases of people, criminals, foreign criminals, arrested, convicted, and deported who came back to Canada using fake papers. Under the biometric visa system, this will effectively be virtually impossible. We'll be able to identify them when they come back using fake papers. It will substantially improve immigration security and ensure as well that deported, failed refugee claimants don't return on fake papers. Collecting biometrics gives us a tremendously effective tool to stop those who mean to do us harm or abuse our generosity. In closing, with the introduction of the Protecting Canada's Immigration System Act, our government is making it clear. If you are a bona fide refugee, you're going to get protection in Canada. If you are a law-abiding immigrant, you're more than welcome in this country, which maintains the highest level of immigration in the developed world. But if you intend to come here as a criminal or to abuse our generosity, you will be stopped or you will be returned promptly. That's what Canadians expect. Thank you.
Merci, ministre. La prochaine question, c'est Daniel Thibault de Radio-Canada Télévision Service.
L'année dernière, vous aviez fait adopter votre projet de réforme de la loi sur les réfugiés. Plusieurs avaient salué votre capacité de compromis. À ce moment-là, vous aviez réussi à obtenir l'aide des partis d'opposition. Qu'est-ce que vous dites à ceux qui regardent de ce que vous déposez aujourd'hui, qui disent qu'essentiellement, vous utilisez votre majorité pour revenir sur tous les compromis que vous avez faits il y a un an?
Tout d'abord, je dirais que nous incluons dans les réformes proposées aujourd'hui certains des propos des partis d'opposition. Donc, on a eu un très bon débat, mais ça a été dans le contexte d'un Parlement minoritaire. On a fait un engagement auprès des électeurs dans la campagne de 2008 d'avoir une réforme fondamentale du système de l'octroi de l'asile au Canada. Et on était très clair de nos intentions là-dessus. Donc, le point, c'est que ce n'est pas un jeu politique, c'est une question de l'intégrité du système. C'est une responsabilité de n'importe quel gouvernement, de n'importe quel pays, à protéger l'intégrité de notre système d'immigration, de nos frontières, de notre système d'asile. Et c'est ce que nous faisons aujourd'hui. Franchement, on a vu depuis l'adoption de C-11 en juin 2010, on a vu une vague des faux demandes d'asile provenant de l'Union européenne. Et écoutez, actuellement, nous avons une seule outil pour s'adresser aux vagues des faux demandes d'asile. Ça veut dire l'imposition des visas. Et comme vous savez, dans la situation de la Mexique, de la République tchèque et d'autres pays, les impositions de visas nuisent à nos intérêts diplomatiques et commerciaux et l'industrie touristique, etc. Donc, maintenant, nous n'avons pas un choix. Si nous faisons face à une vague des faux demandes d'asile provenant d'un pays démocratique, il faut tout simplement imposer une visa. Mais on a besoin d'autres outils. C'est l'outil que nous cherchons aujourd'hui dans la désignation de pays sûrs et un système accéléré pour qu'on puisse décourager les faux demandeurs d'asile provenant de tel pays, pour qu'on puisse reconsidérer les exemptions de visa pour tel pays. Et ça, c'est très important. Donc, on veut avoir une libéralisation des visas pour les pays démocratiques, mais on ne peut pas le faire sans les réformes que nous avons identifiées aujourd'hui.
Une question supplémentaire. Vous dites que ce n'est pas un jeu politique, mais que vous aviez promis une réforme en 2008 et que vous allez dans cette direction-là. Est-ce que ça a toujours été clair pour vous que, en situation de gouvernement majoritaire, il y aurait des étapes supplémentaires qui seraient implantées?
Oui, bien, écoutez, en 2010, quand on a eu le débat sur le projet de loi C-11, à ce moment-là, j'ai été clair que les propos n'étaient pas finaux, que c'était un work in progress, qu'il faut toujours faire les modifications parce qu'il y a toute une industrie des passeurs, des gens qui organisent les vagues de faux demandes d'asile, et ils cherchent toujours les faiblesses de notre système. Donc, il faut toujours avoir une certaine flexibilité pour répondre aux nouveaux développements dans le domaine de notre système d'asile. Et c'est ce que nous faisons aujourd'hui. Franchement, avant 2010, on n'a pas vu la même vague provenant de l'Union européenne. Alors, il y a eu une certaine, mais l'année dernière, on a reçu 5 800 demandes d'asile de l'Union européenne. Et comme j'ai dit, 95% sont trouvés faux.
Next question is Roger Smith, CTV National News.
Yeah, same question, Mr. Kenney. You proposed reforms, you passed reforms to the refugee system. You made some compromises to add safeguards demanded by the opposition. Is this simply a case of your government using its majority to push through what you couldn't do as a minority?
Well, actually, I think the bill that we achieved in 2010 was a good bill. It was certainly a huge improvement over the status quo. And we worked with the opposition in good faith, and we ended up with a bill that was a huge improvement over the status quo. But we have a serious problem. We're facing a large wave of unfounded asylum claims coming from the European Union in particular. The only tool we have to address that now is the imposition of a visa. That hurts Canada's commercial diplomatic interest. It hurts the tourism industry. And we need other tools to address it. And this was the point I made in 2010. We were very clear. We needed a strong tool precisely to counteract large waves of highly organized fake claims coming from safe democratic countries that respect human rights. The opposition didn't agree with us. And the choice we had was either an improvement or no bill at all. In the context of the minority, we thought the responsible choice was an improvement over no reform at all. So we got the improvement, but now we're taking the next step, we believe the necessary step, to protect the integrity of our immigration system. You know, and in terms of safeguards, let me be clear about this. We are adding safeguards even with today's reforms. We are putting in place, within a few months of the passage of this bill, we will have in place the new Refugee Appeal Division. That has never existed in the past. The previous Liberal government committed to it, didn't deliver it. This will give the vast majority of asylum claimants who are rejected at the IRB at the first review of their case a full fact-based appeal for the first time. So I think from an objective point of view, this is a significant improvement in terms of safeguards. But, you know, frankly, we didn't hear ideas from our colleagues in the opposition about how effectively to tackle the problem of thousands of bogus claims from democratic countries. And if they have ideas about that now, I'm all ears.
Supplementary, will you be removing the visa requirements for the Czech Republic and for Mexico? And if so, how soon?
Well, Canada, of course, reserves the right to maintain visas on foreign nationals. That's the default position of our law, and we have a visa requirement on roughly 150 of the about 200 countries around the world. We constantly analyze country conditions and immigration trends from various countries. No decision has been made, for example, in the case of those two countries. Let me say this. We've been explicit. We would like to get back to a visa exemption for Mexico. We would like a full visa exemption for all EU nationals, but we cannot responsibly do that at this time, given the experience we've had with huge waves of unfounded claims from democratic countries.
Louise Elliott, CBC National Radio News.
Minister, you talked about the safeguards, but when the first act was passed in 2010, it was hailed by everyone, including yourself, as striking the right balance between making the system faster, especially for bogus claimants, but at the same time maintaining a level of fairness that most people agree is necessary, even when it comes to EU countries. There are cases where people have come from those countries who are granted either refugee status or humanitarian or compassionate leave to stay in Canada. So by removing the appeal to the RAD, by postponing any H&C claim until 1 year after a decision's rendered, and by shortening in particular the timeline by which these claimants must produce their very first claim, how can you assure Canadians and potential claimants that the system is still going to be fair enough to make sure that the people who are legitimate refugees are not going to fall through the cracks?
It's a very fair question, and I would say that we will continue offering to all asylum claimants, regardless of their country of origin, a full, fact-based, independent review of their application at a independent quasi-judicial tribunal at the IRB that reviews all of the relevant facts and makes a fair decision. This actually exceeds our obligation under the Charter of Rights as defined by the Supreme Court in the Singh decision. It also exceeds our obligation under the UN Convention for Refugees. For example, most Western European liberal democracies typically, in dealing with claimants from countries that, to use the term of art, are not normally refugee-producing countries, that is to say, safe democratic countries, they give such people, first of all, like the British system, for example, puts them all in automatic detention, and then they get a very fast, cursory review and no appeals. Typically, those reviews are done by the equivalent of a border officer, not meeting our standard of a full quasi-judicial tribunal from which they benefit from all of the usual due process and natural justice. So I would say we go above and beyond what the domestic and international law requires of us. In that sense, I think the system is very reasonable. But here, let's speak frankly about the European Union. We're talking here about 27 member states, all of which are democratic, all of which are signatories to the EU Human Rights Convention, and all of which approximate the highest standards of protection of human rights. Not to say that all of those countries are perfect or that people are never at risk or danger in those countries, but people can move around. The notion that we should be considering a British asylum claimant as having the same likelihood of need of protection as a North Korean or Iranian, to me, is self-evidently ridiculous.
Supplemental, Louise?
No, I just wanted to clarify that
Sure.
the original bill was due to be implemented by June 29th. Do you see this bill, this new bill, as being implementable by that time?
No, the bill will delay the coming into force deadline, so we must have this bill passed before June 29th in order to retool the system that we've been developing. We hope that it would be implemented. My officials won't like me giving a date, but I'll say my target is in the fall, earlier the better, so that we can move forward with the new system.
Next is Carl Nurnberg of Rabel.
Hi, Mr. Minister. We know that a lot of this is about one particular group coming from one country, the Roma coming from Hungary, and you had a meeting, I think it was about 6 months ago, with the Roma community in Toronto. I wonder if you can reflect on that meeting and just tell us what you learned there, what you came away from
Sure.
that meeting.
Well, I also, during that trip, met with border services officers, police officers, social service agencies working with that community. First of all, the meeting reinforced for me that obviously many Roma in Central Europe face difficulty. There's a long, sad history that we're all familiar with. And I have to say the European Union countries are facing up to that. They have a multi-billion-dollar action plan for the integration of the Roma, where the EU is funding an enormous number of educational, social development, economic development projects in Hungary and other Central European countries. I've met with Roma community leaders in Hungary, Romania, and the Czech Republic, as well as the minority affairs ministers in those countries. And this is a issue that those societies are working on. There's no doubt, as I say, that there are acts of discrimination in civil society, and that some people face great difficulty. But it's also clear that the European Union states do not persecute people on the basis of their ethnicity. And frankly, what I heard at those meetings was, my main question was this: why is it that well over 9 out of every 10 European asylum claimants are withdrawing or abandoning their own claim? This is not about my opinion, it's about their actions. Why are they withdrawing or abandoning their own claims? And I heard a number of different theories. One was that they have to wait too long to get an IRB hearing, so they go back to their country from which they allegedly face persecution, which frankly doesn't make any sense to me at all. And another was that I was told, I think by two different people, that they didn't like the bed bugs in apartments in Toronto, which is unfortunate. I can understand that. But if folks are really fleeing persecution, I think they might be able to put up with the sanitation standards in the city of Toronto.
Carl, supplemental?
Are you convinced that that generally speaking, we talked about the European Union, but that the European Union isn't a uniform human rights, doesn't have a uniform human rights situation, and certainly the former communist countries, I think there's a general view they still have a big hill to climb in terms of human rights in many cases, and they haven't entirely got there. I'll just quote you. Vera Messing is a sociologist who the Canadian government consulted in 2002 about the Roma in Hungary. She's at the Budapest Institute. At the time, she was very favorable. She said, Hungary is making tremendous progress. We should give this country credit. Interviewed last year, she said, I wish they'd consult me again. The situation is significantly deteriorated, whereas there were never occupations by paramilitary groups of Roma villages in the past. There are now, where there wasn't a extreme right-wing party called Jobbik occupying a major position in parliament. There is now, where there wasn't actual violence against Roma people 9 years ago. There is now. The Roma have really legitimate reason to feel not just discrimination, but genuine fear in their daily lives, and she's inviting the Canadian government to consult with her again. What's your answer to that sort of evidence?
Well, we're interested in those issues. As I said, that's why I've gone there and met with the minority affairs ministers. We engage with the EU on those issues, and we have been very blunt with our friends in Europe that they must do more in terms of integration of the Roma population. Having said that, as it relates to our asylum system, it's worth noting that last year we received about 5,000 asylum claims from Hungary. The United States received how many? Is it 30? I think about 30 asylum claims from Hungary. Other European countries received trace numbers. Australia received none. So this is not about, frankly, this is not about Hungary, it's about Canada. Why is it that all of these individuals are choosing to come to Canada? And to be perfectly honest with you, people actually, we have people showing up at CBSA Secondary at the airport when they make their asylum claim, asking where they can get their check from, their welfare check. And it's very clear that we have our generous social benefits are acting as a significant pull factor. There has been a series of investigations and criminal prosecutions and successful convictions in the Hamilton region dealing with Hungarian asylum claimants who had been scamming the Ontario welfare system, and some kingpins who had been coaxing people over here and then putting them into a human trafficking situation of almost forced indentured situation. This is a very serious problem. And so I think we're mindful of the problems that exist in Europe, but we should also recognize that if people really need protection, they would be showing up, making asylum claims, and going to the IRB. But I reiterate, well over 90% of these people are choosing to abandon or withdraw their own claims, which is saying to our system that they don't need Canada's protection.
Prochaine question, c'est Ray Fillion de TVA.
Juste savoir, M. Kenney, est-ce que vous l'attribuez cette hausse soudaine de demandeurs d'asile?
Excusez-moi?
Pourquoi la hausse soudaine?
Oui. Alors, je dois dire que ce n'est pas quelque chose de nouveau entièrement. En 1995, le Canada a donné une exemption de visa pour la Tchécoslovaquie et l'Hongrie à ce moment-là. Et on a vu une vague des faux demandes d'asile provenant de ces pays. C'est la raison pour laquelle le gouvernement précédent a réimposé le visa sur la Slovaquie et la République tchèque en 1997 et enfin sur l'Hongrie en 2000. Parce qu'on a vu pendant ces 5 ans plusieurs milliers de faux demandes d'asile provenant de l'Hongrie. En 2008, on a dit, écoutez, ces deux pays, ils se sont rejoints à l'Union européenne, les conditions sociales ont amélioré, les gens qui étaient les demandeurs d'asile ont beaucoup d'autres pays d'aller. S'ils font face à la persécution, la discrimination, ils peuvent réinstaller dans les autres 26 pays de l'Union européenne. Donc, on a dit, on peut donner l'exemption aux États de l'Europe centrale à nouveau. On l'a fait en 2008. Tout de suite, on a vu cette vague provenant de la République tchèque, au point que par l'été de 2009, on a reçu environ 500 demandes d'asile provenant de la République tchèque par mois. Donc, on a réimposé le visa sur la République tchèque. Et à la suite de ça, on a vu l'augmentation de l'Hongrie. OK, ça a été quelque chose qui est arrivé plutôt dans les derniers 18 mois. C'était une grande augmentation provenant de l'Hongrie. Je crois, d'après nous, d'après les reportages en Hongrie, dans les médias, d'après nos enquêtes auprès de la population des demandeurs d'asile ici, il y a une rumeur, il y a une histoire, toute une histoire dans la communauté qu'on peut venir au Canada et profiter de bien-être social et de toutes sortes d'autres programmes sociaux, l'assurance de maladie. Et donc, ça veut dire qu'ils croient que effectivement, ce qu'ils nous disent est, vous autres, les Canadiens, vous nous permettez de venir ici et ramasser tous ces bien-être, tous ces programmes sociaux. Donc, c'est la raison pour laquelle il faut diminuer les facteurs qui encouragent les gens de venir ici.
Non? OK. Martin Berger, le service radio de Radio-Canada.
Monsieur Kenney, jusqu'à quel point les mesures que vous annoncez aujourd'hui auraient été nécessaires ou souhaitables quand vous avez adopté la loi en 2010?
Écoutez, c'est vrai que la plupart des mesures que nous proposons dans les modifications aujourd'hui étaient dans le projet de loi C-11 original en mars 2010. Ça veut dire un accès, pas d'accès à la section d'appel pour les demandeurs débutés provenant des pays désignés. Donc, je dirais que la majorité des choses que nous proposons aujourd'hui étaient proposées originalement. Comme j'ai dit, le projet de loi que nous avons développé à la suite des compromis, des pourparlers avec l'opposition était une grande amélioration, mais d'après nous, ça ne va pas, c'est loin de parfait. It doesn't go far enough parce qu'on a besoin de plus des outils, particulièrement pour les pays sûrs.
Donc, ce que vous dites, c'est qu'on est ici aujourd'hui parce que vous avez dû faire des compromis à l'opposition, c'est ce que vous dites?
Non, oui, je dis que le projet de loi de 2010 était une amélioration du status quo, mais ce n'était pas suffisant pour être efficace quant aux défis à l'intégrité du système.
Next is Janet Peskova, World Business Press Online.
Mr. Kenney, we all, or not all know, but some of us know that Roma people can make up stories how tortured and how hard their life is back at home. And we can say that it is organized crime because they come here in big masses. They know what to ask for from Canada. Could you translate it into money? And why do they leave? Why is it so worth for them to come to Canada?
Well, we've asked people this. We've asked Hungarian asylum claimants this question, and the Hungarian media has asked this question. And people say to us very bluntly that look, I mean, this is not a question of speculation. We actually have criminal convictions in Hamilton where people are admitting, or have been found guilty because they went and signed up with Ontario Welfare, and the checks kept flowing even if they went back to Hungary. And the checks sometimes were being collected by kingpins in their community. And people are being told, if you come to Canada, the cost of a one-way ticket is whatever, $800, and you can make that back in social benefits, and here's how you register. As soon as you get that card saying that you're an asylum applicant, you get a federal work permit. And with the federal work permit, you get access to the GST low-income credit, the child tax benefit, and various other federal social benefits. And with the status of an asylum claimant, you can go to the Ontario Works and collect Ontario welfare benefits. And so people have told us that this is an attractive series of benefits and that there's no reason not to do it. Effectively, people have told us that since we permit it, they think it's entirely legitimate. And what we're trying to say today is, I'm sorry, but that's not what our asylum system is for.
Well, they will figure it out. and they're very good at it. Could you tell me how many Roma people are currently in Canada? And because they don't work, they like to collect things. How are they doing here?
Well, we don't track any claimants based on their ethnicity. I mean, people will tell the IRB in many instances that their claim of persecution is based on ethnicity. We only track people by their country of citizenship. So we know that there are, last year, 5,800 claims from the EU, 5,000 of which were from Hungary. Most of the others were from Slovakia. We had a large wave from the Czech Republic until our visa imposition in the summer of 2009. And frankly, because we don't have information on when people leave Canada, we don't know how many have stayed in Canada. We do know that a significant number who withdraw their applications are going back to Hungary. I don't have a precise number, but a significant, last year, I believe, in the range of 95% of Hungarian asylum claimants withdrew or abandoned their own claims. They either came to us and said, I'm withdrawing and going back to Hungary, or they just didn't show up for the hearing. Those that didn't show up for the hearing may still be here, we don't know. And one of the things we're working on is better information sharing with the provinces so that when we know someone has left the country, we can inform the province and they can ensure that they're not sending welfare to someone who's no longer in Canada.
Next is David Battistelli of Rogers Omni Television.
Minister, just picking up on your response earlier to Louise's question, and you said there's a full and fair fact-based review. Now, but earlier when in your statement, when you were talking about the Refugee Appeals Division, you're saying you're reducing options for bogus claimants. By using bogus instead of failed, are you not perhaps tainting or poisoning the well for all of these people from whatever safe country you've designated and really not making the process unfair?
No, I just think that word that's common parlance to describe someone who makes a fake asylum claim. And in fact, if you want me to use the technical legal language, that we have a category here for manifestly unfounded claimants or claims that are made with no reasonable basis. But quite frankly, most Canadians don't use the technical terminology. They know when someone's trying to scam our system, and I don't mind using plain language.
All right, and a follow-up, what these measures, what impact or what potential impact could they have on judicial review at the federal court for these failed claimants?
Sure. Well, all failed claimants will still be able to make an application for judicial review at the federal court, but for those who are coming from designated safe countries, that application will not automatically suspend their removal. So they could make the application. The court will consider it, but we will commence removal proceedings in most of those cases. We'll certainly have the option of doing so. This replicates the system in the United Kingdom, where failed claimants coming from designated safe countries get what is called a non-suspensive appeal. They can appeal, but they may also be removed. And that's based, by the way, on the presumption that they're coming from a country that doesn't normally produce refugees, that complies with human rights standards, that offers protection. And let's not forget, in the European Union, these people have mobility. You can be in Hungary and have a nasty neighbor and say, I want out of here. You can move either to another city in your own country or to one of 26 other countries. And so why people have to come to Canada as opposed to the US, Australia, anywhere else in Europe? Well, I think I've already answered why that's happening.
Next is my colleague in the white jacket, whose name I can't recall. Remind me of it, sorry.
It's Kristen Shane from NBC Newspaper. One question is regarding the human smuggling aspects of the bill. You are changing it to, I guess, exempt people from under 16 from the detention aspects of it. I wonder why you're doing that and if it has anything to do with claims by some critics that it was unconstitutional in the first place.
Well, we believe that it is constitutional. It was never our intention to apply the enhanced detention provisions to unaccompanied minors who arrived in smuggling events, and this amendment simply clarifies what our intention was. Let me say, with respect to the use of detention, that, well, first of all, not only will unaccompanied minors not be subject to the detention provisions in this bill, but bona fide refugee claimants will be released from detention, and if they get a positive decision from the IRB, which should happen in about 3 months upon the referral of their case. And let me just say that, you know, the critics of this have suggested that this is somehow unprecedented or draconian. To the contrary, Canada makes far less use of detention as a tool for immigration integrity than virtually any other Western liberal democracy. If you go to Australia, the United States, the United Kingdom, most Western European countries, many of them detain all or the vast majority of regular asylum claimants, not just smuggled claimants, and they do so until the cases are determined, which can be well over a year, without review. So what we're proposing as an enhanced use of detention for large numbers of people who arrive in one event where it puts a massive burden on our police and intelligence agencies to do the security checks, to verify their identity. It's very difficult to do that for several hundred people instantly, and while at the same time managing these constant detention reviews. So we're simply asking for an effective tool to address huge numbers of people who come in one large arrival. I should also point out, by the way, that these two bills are complementary. The bills we're bringing together are complementary because we believe that some of the large numbers of unfounded claimants coming, for example, from the European Union may very well constitute smuggling, human smuggling. We had a flight a few months ago. We've had at least one flight from Europe where over 90 of the passengers disembarked and went on to make immediate asylum claims, almost all of which were identical at Pearson Airport. Now, that doesn't happen by accident. That's clearly coordinated. And based on the information we have, these folks are being coached. They might pay someone for the advice to kind of like, if you will, a bogus refugee travel agent who puts together the logistics, who coaches people on how to make the claim, on how to enroll in the welfare system and so forth. These things are not happening coincidentally. So in a situation like that, the Minister of Public Safety might, if evidence suggests it's a smuggling event, designate a flight arrival as an irregular event, as a smuggling event, to trigger the smuggling provisions, including the enhanced detention provisions. So the two bills are complementary.
And a supplementary on that, just regarding the designated countries of origin and the decision of how you designate a country into that realm. I know previously there was a committee made up including experts, human rights experts, and that's being taken away. I wonder why you're taking away that, when some might say that that was an extra level of scrutiny, and you're bringing it more to the political level, whereas it was previously at a more objective.
Well, let me just say that these designations will be made on an objective basis. First of all, the bill I tabled today includes criteria in the law on how a country will be designated by the minister. So that wasn't in C-11. It is in today's bill. So that's in the law, the certain criteria. And secondly, the criteria that we are now proposing is that a country from which at least 60% of the claimants withdraw their own claim, or from which at least 85% of claims are rejected by the IRB, will be considered a designated country for a fast-track treatment. If there are not many claims, if we don't get 30 claims from a particular country, we'll look at qualitative factors. Are they signatories to the relevant international conventions? Do they have an independent judiciary? Do civil society groups function? Do they offer protection to their citizens? So these are not arbitrary criteria. These are objective criteria, but we needed a faster, more flexible tool to be able to address emerging spikes in claims. The problem with the system that we proposed in C-11, in retrospect, is that it was cumbersome and too slow moving. I'll give you one example. Right now we're getting virtually no claims from the Czech Republic because of the visa. So the Czech Republic wouldn't qualify under our current system. So if we get around to giving them a visa exemption, all of a sudden I predict a large wave of claims, and we won't have the tool to address that. This will allow us to put that tool in place prospectively for a country like that.
Leslie McKinnon, CBC National Television News.
On that
point, since you're not doing anything to change the visa requirements for the Czech Republic and for Mexico, and those countries have expressed quite a bit of consternation about that, why not impose one for Hungary? I mean, what would be the repercussions in this country from the community and also from the EU if you were to do that? Because that seems like a solution.
That's, well, as I said, Canada reserves the right to impose visas on nationals from any country of origin based on the country conditions and immigration trends. And let me say that we are working closely with our partners in the European Union, including Hungary, to address these issues. We need tools apart from the visa imposition, which is why I'm bringing in this bill. And I will just reserve further comment on that issue because we don't speculate on impositions. But I think it's an entirely reasonable question.
So sorry,
we don't have a visa on Hungary, and you know, our preference is not to use the visa tool. Obviously, our preference is visa-free travel with as many countries as we can reasonably do that with, for commercial and diplomatic and other reasons. So that's our preference. But ultimately, if we feel we have no option but to impose visas, we will always reserve the right to do so. And I just can't speculate. I'm not going to go through all 150 countries and say whether we're considering at some point a visa imposition. I'll just say we have a policy framework which we will use if we believe it's necessary.
Go.
Minister, you said that the 2010 bill, which you reached a consensus with the opposition, still had some gaps. You said it wasn't sufficient in order to be effective. And I know you just brought up one example of one of those gaps. You said it took too long. I'm just wondering if you can zero in technically on what was wrong with the bill in 2010. I know you said you've had this influx of EU claims and all that, but was it just the time? What was wrong?
A couple of things. Well, the main thing is this. With the changes we're making today, we'll be able to go from taking about 4 months for a manifestly unfounded claimant from a safe country to run the course on the system to about 45 days. So we get a much faster system, which means it's a much less attractive proposition for people to come and abuse our generosity like that. So that's the bottom line. It's a much faster system, which we believe will be more effective at quickly deterring waves of unfounded claims. It's largely about timelines.
And earlier, correct me if I'm wrong, you said you were all ears if the opposition had any ideas. I just want to clarify, does that mean you're open to amendments on this bill at this stage, or is it just going to be if you vote against it, you're voting against protecting Canada's immigration system? Will you entertain opposition?
Yeah, absolutely. We did in the past, and we will again. I would encourage our opposition colleagues to bring forward constructive amendments. You know, and if they have ideas that achieve the objective of a fair but fast system, we will give those serious consideration.
Toby Cohen, Postmedia.
Fair enough, just going back to the visa, but fair enough with the visas, but I understand the Balanced Refugee Reform Act also contained a provision that would allow you to designate particular populations or particular regions of a country, and that's being eliminated in this bill. You know, if we're talking so much about the Roma, why eliminate something like that, which could be used in this situation?
Yeah, we went back to the drawing board on some of these things. We looked more closely at the experience of other countries with similar systems, and we came to the realization that wouldn't be practical. That carving out effect wouldn't be practical. That we have to look at the overall country conditions, whether a country is safe, whether it has protection for people, protects human rights or not.
Just to follow up. We're talking about bogus claims a lot from Europe. We know 4,000 came from Hungary. What are the next top European countries, and how many people are we talking? I mean, you gave the example of Britain, but I'm guessing not a ton.
Well, no, they're mainly coming from Central Europe. So the first would be Hungary, the second would be Slovakia, but we have visas on Czech Republic, Romania, and Bulgaria. Based on our historical experience, we can reasonably assume that a visa exemption for those countries, absent significant reforms to our asylum system, would result in large waves of claims from those countries. So this is partly about, our desire in the long run to get to full visa-free travel with Europe.
Do you know what the total number is for Europe?
At 5,800 last year.
Marie Vestal.
Bonjour, Monsieur le ministre. J'aimerais ça revenir sur le comité d'experts qui devait être mis en place pour dresser la liste des pays sûrs. Là. Je comprends que vous avez dit à ma collègue qu'il y a des objectifs, qu'il y a des critères objectifs dans le projet de loi, mais je ne veux pas mettre en doute vos compétences ou votre expertise, mais pourquoi vous pensez que vous n'avez pas besoin d'un comité d'experts pour vous aider à dresser cette liste-là, puis que vous êtes capable de le faire tout seul?
Écoutez, je vous assure, je ne le ferai pas moi-même seul. J'utiliserai l'expertise et le conseil de mes fonctionnaires, qui sont les experts là-dessus. Effectivement, nous créons au sein du ministère de l'Immigration un bureau pour faire l'analyse et la recherche pour les désignations des pays sûrs. Et évidemment, ce groupe-là va faire référence au rapport des organismes des droits de la personne, de l'autre commissaire pour les réfugiés de l'ONU. Ça veut dire nous ferons les consultations de toutes sortes d'organismes des ONG dans les analyses des pays désignés. Donc, ce n'est pas quelque chose d'arbitraire du ministre lui-même. Il y aura un processus sérieux. Mais on a besoin d'un processus qui est vite et flexible. Et ça, c'est le point de la modification dans le projet de loi aujourd'hui.
Mais reste que, si je comprends bien, c'est vous qui avez le dernier mot. C'est des fonctionnaires, oui. Vous allez consulter des gens, oui. Mais s'il y a des experts qui existent et qui sont professionnels de la question, pourquoi pas les consulter?
Alors, on va les consulter, mais enfin, le processus dans le projet de loi C11 de 2010, là, ça aura pris plusieurs mois pour faire une désignation d'un pays, avec un processus assez long. Donc, pour nous autres, ce n'était pas suffisant pour répondre aux vagues soudaines des faux demandes d'asile.
I'm trying to squeeze two last colleagues under the wire. Tamara, Globe and Mail.
Very quickly, in terms of the visa requirements, the biometrics for travelers, students, and workers from certain visa-required countries, how exactly, which countries are we talking about? And would it be just like any country that requires a visa? You'd be asking for this information, and how long is this data going to be stored for?
So the biometric visa requirement in this bill will allow the government to require that applicants for temporary resident visas submit biometric data, which will be 10 fingerprints and a digital quality photo. This will be phased in over time, beginning with initially certain higher risk countries, but eventually the intention is that this will be a important complement to our visa system worldwide. It's already a global requirement for visitors to the United States, with the exception of Canadians. It's a global requirement for, Australia is doing it in the same phased approach that we are, as is the UK and several European countries. This is the new norm. So, as I say, we're going to start in a phased approach, frankly, because it costs money, and we don't have the resources to invest in the infrastructure worldwide in one shot. It will also actually, I believe, improve and facilitate travel for legitimate travelers to Canada. I know a lot of people are frustrated when they get their when their relatives' visa applications are rejected. Well, getting the biometric data will make it easier for us, in a sense, to approve many applications, because we'll have certainty about the identity of the person that they pose a security risk. So the experience in the UK, Australia, and other countries actually facilitates legitimate travel, and we hope that will be the case here.
I'm sorry, how long are you going to be keeping this data for?
Oh, I'm sorry. I actually don't have the answer to that question. We'll get back to you on that. But I mean, there are, in terms of any privacy concerns, let me underscore that this will not affect in any way, shape, or form Canadian citizens or residents. We're not going to require fingerprints or biometric data of any Canadian. This is about, this is a voluntary thing for those who choose to come to Canada. If they want to come to Canada, we're just simply asking that we be able to verify their identity. And we're consulting with the Privacy Commissioner, and we will certainly have limited use of this information, but we'll get back to you on the timeline.